Hello and welcome to Unspun Live, the Herald's politics podcast. My name is Andrew Learmonth. I am the political editor of the Herald. You will know back in April, the Supreme Court handed down a landmark judgment in a case brought by the campaign group for Women Scotland against the Scottish Government. The justices unanimously ruled that a gender recognition certificate does not alter a person's sex for the purposes of the Equality Act, that the terms man and woman and sex in the legislation refer to biological sex. Now, while John Swinney welcomed initially the clarity provided by the ruling, the Scottish Government has said it is awaiting further guidance from the Equality and Human Rights Commission before issuing advice to public bodies. Now, in September, that prompted For Women Scotland to go back to court, particularly over schools guidance, which allowed pupils to use single-sex facilities in line with their gender identity, and prison guidance, which allowed some trans women to be housed in the female estate. And then, at the end of September, the Scottish Government updated their guidance for schools. They issued new guidance, which said that schools must provide separate toilets for boys and girls. However, they are still going to fight For Women Scotland over the prisons guidance. Now, that guidance states that a transgender woman will not be eligible to be considered for admission or transfer to a women's prison if they have been convicted for a raft of offences, including murder, assault, robbery, abduction, rape, and sexual harassment. It then goes on to say there is an exception to this rule if the Scottish Prison Services Risk Management Team and subsequently an executive panel are satisfied there is compelling evidence that they do not present an unacceptable risk of harm to those in the women's prison. Now, For Women Scotland argue, well, that approach is unlawful because after the Supreme Court's ruling, biological sex has to be the deciding factor. And that means prisoners, people who are born male, no matter how they identify, no matter what the circumstances, should not be placed in the female estate at all. So earlier this month, the Scottish Government's lawyers successfully persuaded the court session to hear that to treat that as a full judicial review. We'll get a substantive hearing later on. But John Swinney was asked about why the government are still pushing ahead with the case last week. He told LBC's Gina Davidson,
that's a live legal case and I won't be commenting on live legal cases.
And then in Holyrood on Tuesday, there was a topical question tabled by Tess White, the Tory MSP, and the same question was asked of Justice Secretary Angela Constance. But she repeated the same thing, saying she couldn't answer questions about this because the matter was before the court.
Thank you, Presiding Officer, and with the greatest respect to you and, of course, all members in Chamber, as this question relates directly to live court proceedings, it is not appropriate for me or any member of the Scottish Government to comment.
Now, this is the bit of the story that we want to focus on for this week's podcast, because it is quite interesting, because Angela Constance's answers in the Chamber sparked uproar from opposition MSPs who basically accused her of misleading Parliament, of telling fibs. They said that she could comment on the case, that the Contempt of Court Act allowed her to comment on the case. So to get some clarity about what the law says here, I spoke to Scott Wortley, a lecturer at Edinburgh Law School, and I asked him if the First Minister and Justice Secretary were right, that they needed to stay silent.
I think there's an issue thinking about where they're both speaking. In that John Swinney saying that he couldn't speak about it was in an interview which was outside the Parliament, outside the Chamber, and Angela Constance's comment is within the Chamber. And what you get is an interaction of three different areas, which dovetail in some ways, but which can sometimes be presented as being a way not to comment on something without it being really clear that any one of them justifies that approach. So it's maybe easier to begin with Angela Constance's position. The standing orders of the Scottish Parliament, there is a rule which, Rule 7.5, is the sub judice rule. And the sub judice rule provides a member may not in the proceedings of the Parliament refer to any matter in relation to which legal proceedings are active, except to the extent permitted by the presiding officer.
Yep.
Now, yesterday, there was a question which the presiding officer had allowed.
Yeah.
And therefore, if the restriction on a case being active meant that you couldn't say anything, the presiding officer is given the power in the standing orders to allow that to be discussed.
Sure.
And the presiding officer, by allowing the question, had done that. And so the sub judice rule seemed not applicable, and so the choice to answer by saying this is a live case and so I can't answer feels like a plea to the sub judice rule, which the presiding officer has already waived. And I was surprised that no one in the points of order flagged that the presiding officer had given this authorization by 7.5, because the presiding officer has a residual power, which is within the standing orders anyway, which is if any member refers to a matter which is active, the presiding officer can shut it down.
Sure.
So within the sub judice rule, as well as that general permission, there is scope for the presiding officer to say, "No, hang on a minute, you've gone too far." The test in the sub judice rule, though, is based on whether proceedings are active in contempt of court, and the contempt of court issue is the second one here. Now, contempt of court in Scotland is based on two areas of law.
Sure.
It comes from the common law, but it also comes from the Contempt of Court Act 1981, and both of them are potentially relevant. The common law position is that basically you're not to do anything which interferes with the rule of law.
Yeah.
And so instances of that in the past, if you get rid of court documents that you shouldn't get rid of, if you are releasing prejudicial information about an accused, and you'll be more familiar with that and the implications of that than I am. But this sort of general thing is the contempt rules at common law are to ensure that you're not undermining the administration of justice.
Sure.
The 1981 Act, though, was introduced because the rules at common law were perceived to be too restrictive, subject to general rights of freedom of expression.
Yeah.
Under a European Convention of Human Rights. And I think in your article you mentioned that David Banks is a really, really good and probably the leading media lawyer in the country, a guy who does training for lots of media organisations and the like. David pointed out that change came following a ruling against the UK in the context of the thalidomide issues. Now, the 1981 Act provides protection in relation to publication, but it also gives you a sense as to how the common law provisions apply. Now, one of the things you sometimes get people saying is that the criminal law is where contempt of court really applies, because the issue is about you're not wanting to influence the jury or prejudice a jury.
Yeah.
But it doesn't really apply in civil cases, and that's not strictly accurate.
Sure.
In that a civil case can be affected by contempt of court rules, and in the Contempt of Court Act itself, it's provided that in cases which aren't criminal, then they become active when arrangements for a hearing are made, which in Scotland, the provision is found in Schedule 1 to the Contempt of Court Act, paragraph 14, and it says, look, this applies in an ordinary case when the record is closed, which means that both parties' formal documents into court, their case has been set before a hearing's decided, or if there's a motion when the application for the motion is made, when it's enrolled, or if there is a date for a hearing fixed when that hearing is allowed. So you have the potential that proceedings are active for contempt of court purposes in civil cases, but there is this freedom of expression issue which emerged from the thalidomide case and which you see evidenced by Section 5 of the Contempt of Court Act. And Section 5 of the Contempt of Court Act provides, look, if you have a publication, and normally the rules in relation to publication are very strict, as you know, you and your colleagues are at the highest risk of
tested those rules many times.
Yes. So you're at the highest risk, but if there is a public discussion or a general public interested discussion of matters which would otherwise potentially be subject, then you're fine if there's a publication in relation to that, which is suggesting that at common law, that if you have that discussion, that's fine. That's suggesting that's okay. So while Section 5 specifically targeting the defence for those that are publishing, it's giving an indication as to this freedom of expression exemption being applicable more widely in relation to the rules of contempt, and that would accord with this general idea that at common law, the principal thing you're worried about is the impact on the administration of justice. Is this undermining the rule of law? And so you have the odd position that you would get that if the position taken by the First Minister and the Justice Secretary is correct, it would mean that in relation to any court action in which the government was involved, they couldn't tell you what their defence was. And that seems really bizarre conclusion from their position. And in addition, in a case where here the issue is about the policy which the government has, that policy is something to which they're accountable to the Parliament and to the wider public. So effectively, they're saying we can't discuss discuss this, but they're using a legal justification that seems unsustainable under the contempt of court rules, common law and statute, and also while there could be a sub judice argument, the presiding officer can waive that. The presiding officer can allow that discussion. Now,
so there's another piece of legislation, isn't there? There's another piece that we keep hearing about, which has been raised again, which is the Judiciary and Courts Scotland Act in 8. Now, does that come into play here?
The Judiciary and Courts Scotland Act, and it was Murray Foote who
former
mentioned
SNP chief executive, former editor of the Daily Record.
And again, an experienced journalist, very experienced journalist, and someone they've got a lot of time for. Murray flagged it and said, "Look, does this provision apply?" Because Section 1 of that Act expressly provides that the First Minister, the Lord Advocate, Scottish ministers, members of the Scottish Parliament, everybody responsible in relation to administration of justice, they have a duty to uphold the independence of the judiciary, and in particular, the government ministers, and the wording is, must not seek to influence particular judicial decisions, and then the keywords, through any special access to the judiciary. So I think the point that Murray made, and it's a fair one to raise, is, does this mean that they can't comment? The key word here is must not seek to influence judicial decisions through any special access to the judiciary. There's those two elements there. Now, when the legislation was passed, there was discussion initially, and there were consultation responses at the time that indicated we don't actually need this rule at all. We don't need Section 1 because it's a common law principle. You're just basically stating what the position is anyway, but it was felt that it would have a value to to make it clear within the legislation. But in the background policy memorandum in relation to it, it was stated that this was a statement of principle to a large extent. So it's one of those provisions that you get sometimes in legislation where it's a sort of general statement rather than something that's got teeth, rather than something with sanctions. It was a statement of principle, and it was about stressing that distinction between the role of the government and the role of the judiciary, and what the legislation generally was trying to do was, because you've got the Scottish Court Service being established and the funding relationship with the government and the courts being made clear, it was about trying to draw that distinction between the executive and the judiciary to indicate, look, even though we're financing this, we're not influencing it. And in the background, the special access stuff. When legislation's passed in the Scottish Parliament, it's always passed with supporting documents which are there, which are publicly available, and they're there to help provide a guide as to what they mean. And the notes, the explanatory notes that were published alongside the 2008 Act, they specify in there, look, the Lord Advocate and the Scottish Ministers must not seek to influence judicial decisions through any special access to the judiciary. Special access is intended to refer to any access which they may have, which a member of the general public may note. And so it's using their backroom access that they have, the funding pressure and the like. I don't see how commenting can impact that, when you also have the general sense that anyone that is there as a judge, anyone that is a judge, has sworn the judicial oath and is there upholding the judicial oath and making their decisions based on what they hear in the court. So it feels like the rationale which is given is one which conflates these three ideas: the sub judice principle, contempt of court principles, and the judicial independence, not influencing the judiciary provisions, and it elides them, and it can be a slippery idea that can be used as a way to avoid giving a comment. But if you actually press it and look at it, it's very difficult to see how any one of those three can justify the approach that the ministers take.
Scott Wortley from Edinburgh Law School speaking to me there. I'm very grateful to him for his time and for the clarity of that explanation. I think there's going to be a lot of people in Holyrood who will be listening very closely to what he said. I went to the Scottish Government and just asked for a comment, asked for a statement. They told me it is the Scottish Government's long-held position that it is inappropriate for Scottish ministers to comment on live litigation. In all cases, we have an obligation to uphold the independence of the judiciary. We do not want the government to ever be seen as interfering in the work of the independent courts. Anyway, that's it for Unspun Live this week. Thank you very much for your time. Thanks for listening. If you've enjoyed this, please subscribe. Please tell your friends. We will see you again soon. Thanks. Bye.